let's get started. So there was a big decision from Board of Immigration Appeals this week. And it is about advance paroles,
Yes.
and it has overturned a decision that was in place for about 14 years.
Yes.
Can you talk about what has changed?
Yes. In 2012, the BIA, Board of Immigration Appeals, came down with a decision in the matter of Arabelli, which essentially said if you were to leave the U.S. using an advance parole and you have accrued unlawful presence, that departure will not trigger unlawful presence. So the person would be able to travel. That would be considered a temporary departure from the U.S., and you would be able to come back into the U.S. without triggering the 3 or 10-year bar, depending on how long you had unlawful presence in the U.S. Now, the new ruling in the new case, Del Carmen Lara, essentially overturned that, which means if you leave the U.S., that's considered a departure, and if you have accrued unlawful presence, that's going to trigger the unlawful presence bar, 3 years or 10 years, depending on how long you have accrued unlawful presence. The issue with that is we still don't know how that's going to impact. I've heard that if you come in, it's going to be up to CBP to whether they will allow you to enter the U.S. or they will say you're inadmissible and won't even let you enter the U.S. or let you come into the U.S., claim you're inadmissible, and then if you have an adjustment pending, then you would have to deal with filing a 601 waiver for the unlawful presence.
Okay, so let's step back a little bit, and I will try to understand it better. Let's say I have entered the U.S. 10 years ago or 5 years ago, and I overstayed my visa.
Correct.
Okay, and because I was initially given 6 months, and then I stayed here 2 years. And after that 2 years, let's say I married a U.S. citizen, right? And I wanted to file a green card application. And with that application, I also filed an advance parole travel permission. And even though I was overstayed my visa and I was out of the status for some time, during the past term, before this last decision, I would be able to leave the US, visit my home country, let's say, and then come back and continue with adjustment of status green card application.
Correct.
Is that right?
Yes. Correct.
I was not at risk of getting denied. But now, since I have overstayed, and the total time is more than 1 year.
Yes.
More than 1 year. Yes. Now they say that the admission ban of 10 years.
Yes.
Would apply to me.
Correct.
Because my travel is not under parole or something, and it's a technicality. But
yes.
If I come back, I would be deemed as departed, and now I am subject to 10-year admission ban.
So initially, the old case said when you leave pursuant to an advance parole, that is not considered a departure from the U.S. But now they're saying it is a departure, and it will trigger the 3 or 10-year bar.
Okay.
Yes.
So, but luckily, they say that this decision is not retroactive.
Correct.
Right? So if I have traveled prior to this decision and came back, it will not affect my adjustment of status eligibility.
Or if you left right before August 13th and you want to come back now, it will not apply to people who left the U.S. before August 13th.
Okay, so it is at least they give some kind of period. All right. So what is 3 years and 10 years difference? Who will say that I am subject to 3-year ban or 10-year ban?
Yeah, so it depends on how long you've overstayed. So if you overstayed 6 months or more, but under 1 year, it's a 3-year ban. And then if you overstay more than 1 year, it's a 10-year ban.
Okay, for more than 6 months of overstay, I will get 3 year.
Yes.
But if it's more than 1 year, I will get 10-year ban.
Yeah.
So I think it is not the worst idea that you should not travel if you have ever stayed, if you have ever overstayed. But if it is a requirement, if it is very urgent, then you should maybe, if it is less than 6 months, then maybe you can consider it.
The impact, I think the bigger impact of this decision is previously, if we had somebody who came here and applied for DACA, entered without inspection, applied for DACA, and then would apply for an advanced parole through the DACA. Since they entered without inspection, they didn't have an inspection for adjustment. And then we would advise that you can leave on the I-131 for the DACA and then come back in and be paroled in, and that would be considered an inspection and admission. And then you could apply for an adjustment of status from inside the US. So this also takes that away.
Yes, so it's the bigger impact.
Yes.
My scenario was about someone who entered with a B2 tourist visa, but there are maybe hundreds of thousands of DACA recipients who entered without inspection and then like they were here illegally, and then they were given DACA, and to be able to adjust based on, let's say, marriage, they had to leave and come back.
Correct.
But now it's not possible.
Correct.
I hope many people have already traveled and came back, so they are eligible for adjustment, but this is the issue right now. Do we have anything else to mention about this?
Not about this, no.
Okay.
That's about it.